So the formal proceedings will now begin. Martin will speak for 10 minutes to introduce his thoughts. Jacob Rees-Mogg will follow for 10 minutes. Then we will have a discussion amongst all of us, and at the end, each of our speakers will sum up for 5 minutes formally. Martin Howe.
Right, well, good morning or good afternoon or good lunchtime, everybody. I'd first of all like to thank Politeia and Sheila, first of all for publishing the pamphlet I produced about a year ago, to which she referred, on the concept of a bill to safeguard the fundamental sovereignty of the United Kingdom Parliament. Secondly, for organising this session today to discuss that and other matters of considerable significance. And also, thank you everyone today for having had enough interest in this matter to come today. Very, very pleased to see you all here today. Now, sovereignty, the current European Union bill is quite an important measure, a constitutional measure. And there are two aspects to it. One is the so-called sovereignty clause, clause 18, which I'll just briefly talk about as to where we are on that front. And the other part of the bill, which is also of very, very considerable constitutional importance, are a series of safeguards regarding the mechanisms by which further or future extensions of the power of the European Union are subject to democratic control and accountability within this country. So if I can deal first of all with the question of sovereignty. The European Court of Justice, since before the time the United Kingdom joined the European Economic Community, as it then was, has developed a doctrine, the doctrine of primacy of community law, under which, according to the thoughts of that court, community law is, as it were, a self-contained and self-executing system of law which overrides the laws of the member states. Now, the traditional legal doctrine under this country's constitution is that rules and laws arising from treaties have no effect in our internal domestic law unless Parliament gives effect to them. And Parliament did give effect to community law through the provisions of the 1972 European Communities Act. And the prevailing thought, and this has always been the thought that has been expressed in judicial statements on the subject, has been that what Parliament has conferred, Parliament can take away. And in fact, if one looks to the legal systems of other member states, and those who are really interested in it can see various court judgments set out in the pamphlet that Sheila referred to. Similarly, they do almost all reserve the ultimate right of control over the extent and scope of community law, which we now must call European Union law after the Lisbon Treaty. And under various constitutional arrangements, normally the constitutional arrangement says that European Union law will prevail over, if you like, ordinary laws, but ultimately it's subject to the limits of the Constitution, and that's particularly clearly the case in Germany. Now, the problem this country has faced up to now is that the doctrine of supremacy of Parliament, under which Parliament can't curtail its sovereignty and has the right to take back any powers it may have granted, if you like, or temporarily granted to the European Union institutions, is that is a common law doctrine. It arises out of constitutional practice and history. It's not, and the judgments of judges, it's not actually written down in a constitution of the United Kingdom, since we don't have a written constitution. And therefore, the theory that I certainly have been propounding is that it is important that this is written down in a formal way in statute law to prevent, in a future occasion, perhaps a situation of political crisis, doubts arising as to this fundamental doctrine. Therefore, I'm extremely pleased to see included in this bill, Clause 18, a statement to that effect. I have a if you like, a comparatively minor quibble about the drafting of it, in that I think that it could well have preferably being inserted by amendment into the 1972 European Communities Act itself. So there would then be no doubt that clause 2, section 2, subsection 4 of that act cannot override it. But that, I mean, that is a comparatively minor query or quibble, if you like, compared with the fundamental issue that it has been included in the bill. Now, let me move on to the other part of the bill, which I think is very significant indeed. And that contains both what is referred to as a referendum block and also a number of provisions requiring parliamentary control over the actions of ministers when they agree to certain decisions and actions within the European Union framework, which would result in a transfer of sovereignty from the United Kingdom. And this part of the bill is in principle, again, very much to be welcomed. The cynic in me says that only a government in the first few months of its life would put forward a bill like this, because after they've been in office for 3 or 4 years, they'll be thinking of ways, well, how can we avoid putting all this to Parliament? But in their first flush of coming into office, this is what they're doing. And I think anything I now say about scope and so forth is comparatively, should be taken in context, in the context of the overall thrust of proposals, which are very much to be welcomed. Now, first of all, the referendum lock, so-called, which we've heard of, the part of the bill is probably most famous, under which the idea is to prevent the sort of action which Stuart attempted to prevent the last government from taking through legal action, namely coming along to a general election, promising a referendum, and then failing to deliver on a rather spurious pretext that a few commas have been changed in the treaty, the one they promised the referendum on. And therefore they didn't have to offer one. So the first provisions of the bill are intended to make sure that if there is an action, if there is a new treaty that a future government, this government for that matter, enters into, transfers powers from the United Kingdom to the European Union, then there must be a referendum. Now, there's a fundamental difficulty in creating a secure referendum lock under our Constitution, and it arises from the very doctrine which Clause 18 is seeking to protect, the doctrine of sovereignty of Parliament. Because even if the Act says in terms you cannot do this without a referendum, nothing in our Constitution will prevent a future Parliament passing an Act which says we override that and we're going to give effect to this treaty without a referendum. And the only way we could change that, well, there's a sort of comparatively minor way it could be partly entrenched, and that's by amending the Parliament Acts to require the consent of the House of Lords. Now, a very limited category of bills are subject to the consent of the House of Lords. The House of Lords can't be overridden. And basically, it's bills to extend the life of the House of Commons, which it was felt Commons alone should not be able to override the Lord's veto on that. Now, you could add bypassing the referendum block to that, and that's an interesting constitutional debate as to whether that would be worth doing. In the European Union context, of course, the question which might arise is the House of Lords, under its present constitution, a safe guardian of our constitutional rights vis-à-vis the European Union? and given the constitution and membership of the House, the question mark might arise. The other way would be to move fundamental change to a written constitution. Then you could fully entrench it. And I've got an example that I've researched. Article 6 of the Constitution of the Republic of Singapore says, "There shall be no surrender or transfer, either wholly or in part, of the sovereignty of the Republic of Singapore as an independent nation, whether by way of merger or incorporation with any other sovereign state, or with any federation, confederation, country or territory, or in any other manner howsoever, unless such surrender, transfer or relinquishment has been supported at a national referendum by not less than 2/3 the total number of votes cast by the electors registered under the Parliamentary Elections Act." And there is then Article 9 of the Constitution says you can't amend Article 6 without a referendum in which 2/3 of the people vote in favour. So we have there a fairly secure lock, which I think arises out of Singapore's unhappy historical experience of having been incorporated into the Federation in Malaysia for a brief and unhappy period. But short of doing that, the referendum lock in this bill cannot be an absolute lock. It simply can't, however it's worded, however it's drafted. Therefore, it can only be, at the end of the day, as strong as the political consensus behind it is strong, and as strong as it would be difficult for a future political party to an election to come forward with a commitment to overturn it and deny the referendum rights which it confers. I think some controversy has arisen over the use of the power in it in certain circumstances for a minister to say there shouldn't be a referendum on the grounds that the transfer of power involved in a decision is not significant. Well, I think two problems arise there. One is that there are some people who argue you shouldn't have this exception at all. And I think the problems of doing that are, first of all, that it could give rise to a referendum on something totally trivial and ridiculous. And so discredit the concept of referendums. And the second is, if you didn't have any exception there for insignificant transfers, if you don't have any within the machinery of the bill, a future parliament would be tempted simply to override the bill, saying that, say at a political level, this is insignificant, we're going to override it, and there would then be no control whatever. Whereas if it's done under the mechanism of the bill, there is control, albeit imperfect control, through the possibility of judicial review. So referendum lock, I think, good and to be welcomed, and it's difficult. I mean, there are improvements in the machinery that could be made, but it's difficult to improve fundamentally unless you go over to a written constitution. Now, the third aspect of the bill, which I think is again, extremely to be welcomed, is a very considerable extension of parliamentary control over the actions taken by ministers in the context of the European Union legislative procedures. Now, what was, when the 1972 European Communities Act was passed, it was recognised, for good or ill, that there was a transfer of sovereignty from the United Kingdom to the institutions of the then common market. What was less widely recognised is there was a massive transfer of legislative power from Parliament into the hands of ministers. This is because the principal lawmaking body in the European Economic Community, as it then was the Council of Ministers. Ministers vote in that, Parliament does not vote directly. There are imperfect, Jacob here on the committee, imperfect scrutiny arrangements undertaken by the Houses of Parliament. And the problem with them is they don't have legal force, they just rest on resolutions of the House in political convention. So ministers can say with impunity, oh, I'm frightfully sorry, well, it was all terribly urgent and there wasn't time to consult you, so I had to agree to all this. And there's absolutely nothing that the European Scrutiny Committee or Parliament can then do about it, because the United Kingdom is bound by it. So what this does is, and one particular power, which it's been a scandal ministers are allowed to exercise without parliamentary control, was the power under Article 235 of the Treaty of Rome, which is to legislate generally in aid of the objectives of the treaty when there's no specific power in the treaty to allow the relevant action to be taken. And this has been a gateway through which significant extensions of powers and creation of new institutions has taken place. And that, under the bill, will now be subject to approval by Act of Parliament. Now, but the other area which is significant, there's one important omission, though, that I will conclude by mentioning. And sorry to be a little bit complicated in explaining it, but it relates to the area of freedom, justice and security. Now, under the Maastricht Treaty, and again I apologise for getting highly technical, the so-called three-pillar structure of that treaty involved the European community being, if you like, supranational, and its laws subject to the jurisdiction of the European Court. In the economic field, the second pillar, the common foreign and security policy, which was, as it were, people called it intergovernmental. It's actually not right technically to call it that, but certainly more intergovernmental than the first pillar, and in general outside the jurisdiction of the European Court. And so-called third pillar, justice and home affairs. These are measures such as the European arrest warrant, under which a Romanian judge, for example, can make an order for someone's arrest, and it's executed in this country, and there is no provision, in fact, for the review of the merits of the order by the British courts in any circumstances whatsoever. That is expressly excluded by the Act of Parliament which implements the European arrest warrant. Now, what's happened under a very important provision of the Lisbon Treaty is that there's a transitional provision under which these so-called third pillar measures stay as intergovernmental for 5 years after the coming into force of the Lisbon Treaty, so up to the 1st of December 2014. At that point, they will convert into first pillar measures, will become fully subject to the jurisdiction of the European Court of Justice that will interpret them as is its wont in the most Euro-friendly, Euro-integrationist way, and also has enforcement powers. There is in the transitional provisions of the treaty an important right of the United Kingdom to derogate from it. The United Kingdom may, up to 4.5 years after the date of coming into force of the Lisbon Treaty, opt out of these of the application of these third pillar measures, in which case they will all cease to have effect on the 5th anniversary against the United Kingdom. If we don't opt out, then we'll be bound by them, and a very substantial increase in effective European Union competence will occur by default without any positive action. Now, my proposition is this: although, as a matter of mechanics, this is negative, this is an increase in competence by default, it is at least as deserving of being covered by the provisions of this bill as a positive opt-in step. In other words, unless Parliament consents, we should opt out. And I invite a parliamentary colleague here to consider that issue. I'm sure he will. Because the advantage of opting out is it doesn't mean we would no longer engage in cooperation in judicial police affairs with European Union member states. It simply means we would just renegotiate the arrangements to operate on an international basis instead of within the institutions of the European Union. So I leave you with that final thought. I'm sorry to take a little bit longer than I was budgeted for, but I feel that there's enough meat in this bill to be worth covering.
Thank you very much. And now Jacob Rees-Mogg will discuss. these and other points I didn't.
Thank you. And if I may reiterate Martin's thanks to Sheila and Voltaire, that I have indeed known Sheila for a long time. I think we first met to discuss the then very radical and right-wing view that students might have to make some contribution to their own education. So we were very much ahead of time. And then to speak with Martin is really an honour, because he has been the legal flag bearer for Eurosceptics, I think, since the Maastricht Treaty. So I'm delighted to be on the same platform. And as a starting point, I'm quite pleased to say that I actually put down an amendment on Thursday to the bill to exempt chunks of it from the 1911 and 1949 Parliament Act, so that the referendum law would be slightly more locked in. Whether the government will accept this is another matter, but in my view it will go some way to show you how serious they are. And I think this is one of the issues with the whole bill, that there are a lot of Eurosceptics about who feel that governments have misled them since 1972, and that when a new big bill comes along and it's said that it's going to solve all our problems and save us from being taken over by the European Union, a lot of people say, well, we were told many times that this was never really going to be necessary because we were never really being taken over. So there's a deep gulf of distrust, I think, from Eurosceptics towards what you might call the elite and officialdom that this bill may or may not overcome. It'll be interesting to see as it develops whether it manages that. I would say, as a young and perhaps naive new member of Parliament, I'm perhaps more likely and willing to give Her Majesty's Government the benefit of the doubt than some of my older and more doughty combatants in this particular battle. But to answer the question, the EU bill, the UK and British sovereignty, with whom will power lie? The key answer to this, the most important answer to this, is with the British people. And that everything that ought to be said about this bill is in getting their power properly recognised. Because we discuss at great length the ability of Parliament to bind or not to bind its successors. The reason Parliament can't bind its successors is because it's not its power to give away. It belongs to somebody else. We actually got this in evidence to the European Scrutiny Committee from Vernon Bogdanel, quoting John Locke, about where the power and authority of the House of Commons comes from. It is from the British people. And therefore we are guardians of their power and authority